Hello everybody, thank you for joining us for our lunchtime webinar today. I'm delighted to say that we're being joined by some guest speakers today, and they are Kurt Riley and Angeli Brown, and they are from Myerson's Solicitors. So they're law solicitors from a firm that's 100% employee owned, and they're one of the top 200 law firms in the UK. I need to let you know that today's session is recorded, so if anybody needs a copy afterwards, then please let me know. And we will be taking questions. You can put questions in the question box on the top right hand corner, and then I will ask the questions to Kurt and Angeli at the end of their presentation. So without further ado, I shall pass you over to Angeli, and she will begin her presentation on preventing sexual harassment in the workplace.
Hi, so thank you everyone for joining us this afternoon, and thank you Liz for that introduction as well. So again, to introduce myself, my name is Angeli and this is my colleague Kurt, and as Liz said, we are both employment solicitors at Myerson. For those that haven't heard of us, we are an award-winning full-service law firm in Greater Manchester. So moving on now to our agenda. So I will be covering part one of the presentation, which will last about 20 minutes, and I will be discussing some background and statistics about how this new duty has come about. I'll then be talking about the law, focusing on the Equality Act 2010. And then finally, I'll be unpacking this new duty to prevent sexual harassment in the workplace. Kurt will be covering part two, which will again last about another 20 minutes. And he will be covering the approach to equality and diversity, the standards expected of all, and what employers or employees and managers should be doing. And then finally, he's going to look at what are the consequences of unacceptable conduct. And then finally, we're going to be open for some questions for 10 minutes. So moving on to the background and statistics and about preventing workplace harassment. So why is it important for employers and managers to understand the duty and to prevent sexual harassment in the workplace? Well, I think it's important not only from a business perspective, but also a legal one. So as we know, sexual harassment can lead to high profile departures of senior management, and that often means expensive litigation. It can cause damage to an employer's reputation. So we've all heard of the cases in the media, thinking about Harrods and more recently McDonald's, to name a few. It can have an adverse effect on an employee's relations and also customer relations as well. And then finally, it can also lead to claims. So not only harassment claims, but equally, it could lead to a breach of the duty of the mutual trust and confidence, which could give rise to constructive unfair dismissal claims for employers that have 2 years or more service. So I think before I talk to you about the duty, I think it's important to talk about the prevalence of the problem in the workplace. And I think for an employer to create a workplace that minimises the risk of sexual harassment, we need to understand the extent of this current problem. So on this slide, you'll see that I put forward some statistics. So I'll talk you through these points. So the first one was from the BBC, and they found that 40% of women and 18% of men out of 6,206 respondents have experienced some form of unwanted sexual harassment in the workplace. And this ranges from jokes to more insidious behaviour, such as serious sexual assault. The Fawcett Society, which is the UK's leading charity campaigning for gender equality at home and at work, they similarly found that at least 40% of women have experienced sexual harassment in the workplace. And they found it tends to be women marginalised for other reasons, such as race or disability. They have an increased risk of sexual harassment. So there's often that intersectionality. And And then finally, the TUC, which is the Trade Union Congress, they found that 62% of women between the ages of 25 to 34 and 68% of disabled women and LGBT workers have reported to be sexually harassed at work. So some quite stark figures showing you how prevalent this problem is. So moving on to the law. So I'm first going to talk to you about the EU law. And the European Union was the first one that put forward a definition of sexual harassment. And they defined sexual harassment to be unwanted conduct of a sexual nature with a purpose or effect of violating a person's dignity, and in particular creating an intimidating, hostile, degrading, humiliating, or offensive environment. And there's been a lot of case law about this definition, as you can imagine, and what sexual harassment means. And what is the purpose or effect? Well, it depends on an individual's perception, the circumstances of the case, and what is reasonable objectively. So the Equality Act 2010 incorporated that EU definition and made it into legislation within the UK. And the part of the Act that covers harassment is Section 26, and it prohibits 3 types of harassment. The first one is harassment related to a protected characteristic. So that's one of the 9 protected characteristics set out, which ranges from age, race, religion, etc., disability. The second is sexual harassment, and the Equality Act incorporated that definition that I spoke about from the EU. But it also covers a third part of harassment which is prohibited, and that is less favourable treatment because an employee rejects or submits to unwanted conduct of a sexual nature that is related to gender reassignment or sex as well. And Section 40 of the Equality Act covers or prevents harassment within the workplace. So I've set out in this slide the exact wording, and that really, as I said, introduces this new provision preventing harassment of somebody that's an employee or somebody that has applied for employment as well. So who is protected? I'm going to talk to you and unpack that a little bit more. So an employee, for the purposes of the Equality Act, is actually a lot wider than what you'd typically deem to be an employee in layman's terms. So it covers employees, as we know it, workers and apprentices as well. The key point is that it's whether the individual is required to perform work personally. So if they're required to perform work personally, then they will be caught. And as I said, this also includes those that are self-employed, as I said, provided that there is that personal obligation requirement. And I think practically what this means for an employer is that you have an obligation to ensure that all these people within your business are protected. So when thinking about as I'll come on to preventing sexual harassment, it does really cover a wide category of individuals. So my question is, what might be conduct of a sexual nature? And the Equality and Human Rights Commission have put forward some technical guidance, and they've advised that conduct of a sexual nature can include the following. So it can range from sexual comments, even suggestive looks and leering, to social media posts, spreading sexual rumours, and also the physical as well, including hugging, massaging, or kissing. So again, that conduct is not just physical, but can be verbally or through social media, as I said. And I thought this was very interesting. So the Fawcett Society, who I spoke about, so they found that sexual harassment isn't always motivated by sexual interest, and sometimes it can be used to humiliate or belittle people with a goal to put them in their place or for entertainment for others. And this has been supported by case law. So there was a recent or fairly recent case where a male worker altered a pornographic image by pasting his female colleague's face onto it. He then shared it with his colleagues with the purpose to ridicule her. And this was deemed to be sexual harassment by the employment tribunal. So again, just goes to show that it doesn't need to be a sexual motive for it to warrant sexual harassment. So I'm going to talk to you now about this new duty to prevent sexual harassment. And we may be thinking, so we have the Equality Act 2010, which came out in 2010. So why do we have this new duty when we already have legislation which is preventing sexual harassment at work? Well, the reason being is because this situation, sexual harassment is still very prevalent within the workplace, as I said, from those statistics. But secondly, what further puts it into a context is that it is widely underreported as well. So, 70% of women who've experienced sexual harassment as polled by the TUC, haven't reported this to their employer, and then 67% of affected respondents in a Radio 5 live survey and 50% of respondents in an EHRC survey also stated that they never reported the sexual harassment to their employer. So again, thinking about the early statistics and the underreporting, clearly it is still a significant problem that workers are subject to. So what are some of the barriers to reporting? So again, the EHRC did some research, and they've put across some of the points as to why victims feel reluctant to report it to management. First of all was the view that the organisation wouldn't take it seriously. So they felt that, said over half of the respondents who did report it took no action. So those that did, were experienced by it were very reluctant to, um, off the back of those figures. Secondly, there is a belief that the alleged perpetrator, particularly senior staff, would be protected, a feeling of inexperience or unsupported managers, a fear of victimisation, and Kurt will talk about this a little bit further, but the feeling that they will be put to a detriment as a result of raising a grievance, and then finally a lack of appropriate reporting procedures. So how can we encourage reporting? So I've again thought about this and put together some points to try to encourage staff to raise it to management. So I think the first one is to make sure that victims feel listened to and they have an opportunity to be heard, and explain what happened. Secondly, it's for the perpetrator to be held accountable. So it's important for victims that the perpetrator take responsibility of what's happened. And if we have management that look to minimise that complaint, then victims will understandably feel that their concerns aren't being treated seriously, and it perpetuates that victim blaming culture as well. And then thirdly is to have choice, control, and voice in the process. So victims want to make sure that they are able to make informed choices about the remedies available to them. And often, having gone through sexual harassment, they feel that their control has been taken away. So offering them some control in the process, and how you as a business are going to help them, but just form an important part of justice. So let's unpack the duty to prevent. And I say it's a new duty, but it became in force on the 26th of October of last year. And this amended the Equality Act, and it placed a new duty on employers to take reasonable steps to prevent sexual harassment in the course of their employment. And in the course of their employment, so that can cover incidents outside of regular working hours, such as work social events and work parties. So it can be wide reaching. It is a preventative duty, so employers should think about ways to prevent sexual harassment, not just wait until an incident has already occurred in work to be caught by this new legislation. It also covers sexual harassment by third parties, such as clients and customers. So at present, under the Equality Act 2010, there isn't a prevention of harassment by clients and customers. So this is quite a significant extension of that protection for individuals. But what it doesn't include is sex harassment or less favourable treatment for rejecting or submitted to sexual harassment. So those three provisions of the Equality Act is only preventing sexual harassment rather than the other two. So first of all, what should you as an employer be doing? Well, the first recommendation it would be to complete a risk assessment. So the EHRC considered that this is a very important for every employer. Would be to firstly assess the risk of sexual harassment or harassment and victimization happening in the workplace. So employers should carry out a risk assessment that considers what risks are present within their workplace, what steps can be taken to reduce those risks, what steps would it be reasonable to take, and then finally, employers should implement those steps. So on this slide, the EHRC have identified some following risk factors which may be important to your business. As I said, some will be important to you, some won't, but it's really important that you demonstrate that you have identified those risk factors which are important when making that assessment. So I'm going to talk about some of these risk factors in a little more detail. So the first one is power imbalances, so particularly gender power imbalances. If you have predominantly junior staff that are women and senior management are men, and this is a risk factor to your business. Job insecurity, so if your organisation is made up of a lot of zero-hour contracts or agency staff or other contractors, again, that is a risk. Lone, isolated, and night working. Again, pretty self-explanatory. If an individual is working outside of working hours, if there's a lot of presence of alcohol, again, bearing in mind that in the course of employment could cover work events, that is a risk to consider as well. If you have a lot of customer-facing duties, particularly events that raise tensions locally or nationally. If there's a lack of diversity in the workforce is a risk factor, and thinking about that intersectionality of those statistics as well for women that are disabled or of a different race. If they travel to different work locations, and also working from home as well. So that was it might be surprising to some of you, but the Fawcett Society found that 45% of women surveyed had experienced sexual harassment online, and that can be from sexual messages, cyber harassment, sexual calls, and they said that sexual harassment had increased or escalated at the start of the pandemic when people were working from home. So don't feel that because the majority of your staff tends to work from home that they are protected from sexual harassment happening, because the statistics do say otherwise. Attendance at events outside of a working environment. So again, I'm thinking about training, conferences, where staff are attending social events or working away from home, particularly if alcohol is consumed, then this can be a risk factor. Socializing outside of work. Social media between workers. I've spoken to you about the demographic workforce as well. As I said, if there's predominantly a male workforce, that's a risk factor. A failure to respond to previous reports of sexual harassment, and then finally, workers with more than one protected characteristic. So again, harping on about what I said before, it tends to be intersectional, and those that are disabled or ethnic minorities are more likely to be a victim of sexual harassment in the workplace. So something to bear in mind. So we've spoken about the risk assessment and assessing those risks. So afterwards, you need to think about what reasonable steps, having done that risk assessment, that you as an employer need to do. So what is reasonable? Well, there isn't a one size fits all approach, and it does depend on the size and resources of the employer. You want to think about the nature of your working environment, the sector which you operate in. So if you or your client has a business within hospitality and leisure, some of the risk factors may be around the high customer interaction. A staff member working in a bar, for example, tends to be night work and there's a lot of alcohol involved. So the reasonable step may be focus more on preventing third party interaction. Whereas somebody or a company, I should say, in the manufacturing industry, some of the risk factors may be the fact that it tends to be a male dominated workforce, or the majority of senior management roles are occupied by men. Again, the reasonable step would be looking more about preventing internal sexual harassment, given those risk factors which you've identified. It's also about concerns. Well, secondly, it's about concerns that have been raised with the employer that sexual harassment has been taking place. So again, if you have prevented, well, if one of your employees have put forward a concern of sexual harassment within the workplace, then it would be reasonable for you to carry out an appropriate investigation and to make sure that doesn't happen again. So I spoke about what is reasonable. So I'm now going to talk about the EHRC 8-step guide. So the Equality and Human Rights Commission set out an 8-step guide of what positive action they expect you as an employer to take. This isn't an exhaustive list, and there may be additional measures which you may think to be appropriate for your business. But as I said, as an employer, you and your clients need to demonstrate that you've considered actions these 8 points, which the EHRC has put forward. I'm going to talk through these 8 steps now, but if you are struggling to work out how best to approach these, then please do get in touch, as I'm more than happy to help. So the first one would be to develop an effective and anti-harassment policy. So having a clear and regular updated policy specifically dealing with sexual harassment, and making sure that applies to all staff is often the first starting point. You want to set out what conduct is or isn't acceptable, explain that you as a business have a zero tolerance approach to sexual harassment, and then you want to set out the support available to victims for sexual harassment. And it goes back to what I said about underreporting, about how staff felt they didn't know where to go once they've experienced sexual harassment. So having this policy available is really helpful for that. Secondly is staff engagement. So, do you know in your business how staff feel about sexual harassment? Do they feel that they've been affected by sexual harassment in the workplace? Do you have management buy-in? So how can we get greater staff engagement? It is having regular one-to-ones, running staff surveys, making sure you approach these sort of questions in an exit interview. Obviously not have experienced sexual harassment, but figuring out how the leaving staff member feels about the business at the end of their employment, and then also encouraging an open door policy. Thirdly, it is assessing and taking steps to reduce risk in the workplace. So that goes back to that risk assessment, which I spoke to you about, completing the risk assessment and implementing those reasonable steps is the third point. Fourthly is reporting. So you want to encourage that those that have been a victim to sexual harassment do report it, so management do have that visibility. By doing that, you want to make sure that you have effective reporting mechanisms in place, which provide different methods of how an individual can raise a complaint in a clear way. One tip would be to have more than one reporting channel. So rather than just have, speak to your line manager, you may say speak to somebody from HR, or give staff the opportunity to speak to different members of the business who they may feel more comfortable talking to. And then you want to keep centralized and confidential records of all complaints raised, both formal and informal as well. Fifth is staff training. So you want to provide mandatory training for all staff for what amounts to sexual harassment, and explain the standards of expected of them, and how to raise a complaint as well. You may want to issue out additional training for managers, who would be often the first point of call when handling a sexual harassment complaint. And then 6 is making sure that you follow your own processes of when a harassment complaint is made. And that's why having a really good comprehensive sexual harassment policy can really put you in good stead for that, to making sure that you follow your own investigation procedure to ensure that complaints are dealt with promptly, effectively, and in a sensitive way, and making sure that those perpetrators are held accountable. And Kurt will talk to you about this a little bit further when we go through the practical steps. Seventh is dealing with third-party harassment. So I think the key takeaway is to take it seriously, don't dismiss it. And as I said, making sure that you do have effective measures in place to help prevent or minimise the risk of sexual harassment occurring in the workplace. And then the 8th and final step is monitoring and evaluating actions. So employers should regularly evaluate the effectiveness of that policy, and to make sure that how are these steps that you've implemented, are they working? Again, thinking about staff feedback, surveys, and you can also review the complaint data as well to identify any trends. So that's it in terms of my section. So I'm now going to pass you over to Kurt, and he is going to talk to you a bit more about the practicalities of what you should do as a business once a sexual harassment complaint has been made. So I'll pass you over to you, Kurt, now. Thank you.
Good afternoon, everyone. And thank you to Anjali for a very comprehensive and informative section on the context and the significance of sexual harassment. My name is Kurt Riley, and I'm going to be talking through a little bit more about what it means on a practical kind of level, effectively complying with the duty in practice. As part of this section, I'm going to be touching upon 5 main areas. That is an employer's approach to sexual harassment, the standards we're all expected of, what employees should be doing on ground level, what managers and employers should be doing, and finally, what are the consequences of unacceptable conduct. So starting with an employer's approach to sexual harassment, and I think Anjali's session there has reminded us of, quite frankly, an employer's approach should always be one of zero tolerance. So the Fawcett Society sets out that the culture of an organisation is always one of the greatest predicators of the level of harassment within a workplace. Employees tend to respond to their environment, as you can appreciate. The more seriously it treats sexual harassment, the more seriously its employees are likely to as well. And of course, the inverse is true. Those employers who dismiss complaints, don't train staff, it's more likely to be prevalent in those types of organisation. The Equality and Human Rights Commission essentially goes further than this, describing a zero tolerance approach to harassment as recognising that no worker should have to experience sexual harassment at work, taking all concerns about harassment seriously and acting promptly to take action. Effectively, just to sort of piggyback on Anjali's session, these sorts of issues ought to be brought to the attention of employees during regular training, in staff meetings, on notice boards, posters in the workplace, staff bulletins, newsletters, handbook, whatever it may be, as long as it's communicated to staff. That is what employees should be doing. And finally, Anjali mentioned third-party harassment rules now, and so these policies ought to be communicated with all businesses and organisations which supply workers, and this just ensure a comprehensive understanding is reached across all people in the business and all people who deal with the business too. So what should employees do? And this section is broken down twofold. Firstly, in relation to what if an employee experiences sexual harassment, and secondly, what if an employee witnesses sexual harassment? Because there is a fine sort of tuning there, and of course, being witness is far different to being a victim of sexual harassment. But the place to look in both cases is the ACAS guide, and as difficult as it may be, it's best to make a complaint as soon as possible. Having said that, if there is a length of time between an incident and making a complaint, even if that is months or years later, it doesn't negate an employer's responsibility to deal with it seriously. It is a good idea to make a note of what happened, though, even if you feel nervous in approaching an employer right away. So this should include dates, times, names, including any witnesses. Often, most of these incidents may be just between two people and there are no witnesses or evidence to suggest it happened. And so keeping a documented note of what happened is not only helpful for the purpose of pursuing a complaint or grievance, but it may be of assistance given that often these types of issues will be particularly distressing for victims of harassment. It is possible to try and resolve the problem informally. This may be a report to an employer or somebody senior at work, just for a quick chit chat, and often that will depend on the extent of the harassment in question. Anjali outlined a great deal of something that would maybe consider quite minor to something very serious, which could amount to police action. If it is on the lower end of that scale, a simple word in the ear of a senior manager or HR may be sufficient. Informal resolution, however, is not always appropriate, and it may be necessary to go through the correct channels according to your employer's reporting procedure, as Anjali discussed. So what if you witness sexual harassment? And as I mentioned, the ACAS guide is the place to look here, the authority. Of course, your employer's policy on this should mirror exactly what is in the guide. But essentially, it sets out that if you feel safe, it is possible to stop in and try to stop it happening if you feel it's safe to do so. After it's happened, the most important thing you can do in order to support an employee is chat to them, make them aware that you have witnessed this harassment, and see if they want your support. Of course, it's easier to deal with somebody who is likely feeling distressed or unsupported, to give them an arm around their shoulder, explain that you are happy to support them in any complaint or grievance or non or informal action as they should so require. However, that support is not an absolute bar from you reporting it in any case. It tends to be better if you can have that person offer the same level of support. But of course, sexual harassment affects us all. Even if you simply experience or overhear it, that can still be a form of harassment in and of itself. And so you can take action to report it to HR or whoever is identified in any reporting channel. If you do decide to make a complaint yourself, you do not need the permission of the person who has been harassed. But as I say, it can be of use and support to that employee in question. If, however, you are in support of that colleague, or actually if you are just reporting a concern yourself, you are protected against what's called victimization. So that effectively is unfair treatment as a result of supporting a complaint or being prevented from giving evidence. Your sort of recourse, if that were to be the case, may well be through the employment tribunal, grievances, or other consequences, as I will come on to in a later section of this presentation. So that's employees. Moving on to managers. Now, what can managers do? And we're talking about the duty to prevent sexual harassment. And if you ask me, prevention is always better than cure. So it's about having everything in place so as best to prevent the issues actually crystallizing in the first place. That is not only for managers, but it's essentially being a living and breathing essence of a sort of safeguarding these principles at work. It's about maintaining appropriate standards in the workplace. It's about ensuring all managers, all senior staff are role models. Again, it's important to ensure that the leadership team sets out visibly and openly the fact that we operate a zero tolerance approach to harassment in the workplace, and fundamentally ensuring the employee's reporting procedure and policies are understood by staff. We spoke about the visibility and ensuring awareness, but actually how do we ensure they are understood by staff? E-learning can be a good option for staff to test their knowledge, and any issues with understanding can be identified, and further training can be required if necessary. So that is prevention, but of course things do slip through the cracks, and so what to do if a complaint is received. So I mean, fundamentally, of course, a manager should take a complaint seriously, and that is absolutely sort of, if there's one thing to take away, it would be that. Never ignore or cover up a sexual harassment complaint. I think all of us on the call would appreciate that and understand the significance of subjecting a person to victimization, refusing to progress their complaint on the basis they have raised a serious issue. It's important as well never to doubt a harassment complaint just because nobody else witnessed it. Always handle such concerns with fairness and sensitivity, and keep an open mind. Now, keep an open mind is of particular importance because these complaints will often be made against people with a pre-existing relationship. There are preconceptions as to, well, this person wouldn't have done something like that, or I think this person has exaggerated these complaints. And so keep an open mind can be broken down further. Front and center, then, a manager should never let their own feelings influence how to handle a complaint. And this is of particular importance where the manager gets on well with the person accused of sexual harassment. Ultimately, complaints should be dealt with in a neutral and sensitive way. Even if there is a suspicion that your friend down in marketing might not have ever been capable of something like this, it's important to ensure a fair, unimpeded, and neutral investigation takes place. Second point, much in the same way, if there is a belief the person accused is unlikely to have done it, that shouldn't influence the dealing of the complaint. The same level of investigation, the same level of witness scrutiny ought to be adopted in every case. Again, if the person accused is senior or influential, it might even be your boss. Nonetheless, the investigation needs to proceed unimpeded by the various sort of contexts to the accuser and the accused. This is important, this last point, because there's often a misconception in relation to harassment. And we come back to the statutory definition, and it is conduct with the cause or effect of creating a hostile, degrading, or offensive environment. So there is a situation, you can understand, where the purpose may not have been to offend or degrade an individual, but if it had that effect, it can still amount to harassment. And so no prejudging should be done in the investigation of a complaint. Something that you may not find offensive or unwanted can feel very different to somebody else. And that is certainly a takeaway from this session. So moving on to consequences. What happens if we get this wrong? I'm going to talk through victim support and any actions that will need to be in place once somebody has come forward. Disciplinary action, which is a fairly obvious consequence of this type of harassment. Whether police action is necessary and the extent to which that will impede on a disciplinary investigation or other internal measures. Mediation and where that can be appropriate, any claims in the employment tribunal, and finally to conclude the Equality and Human Rights Commission enforcement action. So victim support. It's of course important that those who report harassment are offered appropriate support by their employer, and that can actually go beyond a chit chat in the office in a private room, but that would generally be the starting point. Depending on the severity of the harassment as alleged, it may be appropriate to offer counselling services. That support, if identified to be worthwhile, should be implemented both during the investigation and after it has concluded, in fact. Those employees who have raised concerns will always want to be kept up to date with the progress of an employer's investigation. So it's important to ensure that there is a mechanism in place to do that in a confidential and appropriate way. I mean, one last word on victim support is effectively that by virtue of being subjected to sexual harassment, it can have quite a serious effect. You know, it can damage their confidence. It can feel as though they lost their voice in this process, and really offering them some control in dealing with the investigation really does become an important part of justice and allows for a more fair process to be actioned as a result. So in terms of disciplinary process, now I've spoken about the risks in discarding an employee's query or throwing it out because my mate never would have done anything like that. But actually there is a balancing act and it goes both ways. So being accused of sexual harassment can have a significant impact on the accused. Employers should ensure that an employee accused of sexual harassment is dealt with in a sensitive way and there is no presumption of guilt made. That's the neutral aspect of the investigation I referred to earlier. And it's interesting to consider the second point here, because it's important to ensure that a consistent approach is taken towards alleged perpetrators in all complaints of the sexual harassment. That could extend right from the CEO potentially, right down to a contractor. Ultimately, the process shouldn't be any different. Everything needs to be neutral. We don't make a presumption of guilt on either side, and we ensure appropriate confidentiality is in place as a part of any investigation.
Hi, Kurt. I'm really sorry to interrupt, but we've lost your volume. No. Sorry, everybody. We love a technical problem.
Hello, is that working?
You're back. Thank you.
Sorry, excuse me. Where did I get up to, please? Oh, I think you're on mute there, Liz. Sorry, I can't.
I think if you start from the beginning of the slide, that will be fine.
Fine, thank you. And apologies to all of you listening. Okay, just bear with me. Yes, so essentially I was saying that in some circumstances it won't be necessary to dismiss an employee. You'll recall that sexual harassment can be suggestive looks, potentially, unintended jokes, that type of thing. And so a final written warning, or other sanction may be imposed instead. In which case, there will be somebody we have dealt with who has raised a sexual harassment complaint, and somebody ultimately we've concluded is guilty of a sexual harassment complaint, and they will be working potentially very close to each other, if not certainly within the same business. So what we can look at in such circumstances is whether further training for the harasser is required. We can also look at permanent redeployment of the harasser to another role, if that is, of course, possible within the business, or if the complainant would prefer, we can look to redeploy them, or other measures to keep the parties separate, be that through the organisation of different reporting lines, for instance, or other appropriate measures. And finally, asking the harasser to apologise to the complainant can do a lot in terms of repairing difficult relationships. If the harasser shows contrition and acknowledgement of the significance of their actions, that can be a useful step to consider too. It's important that I do make reference to false allegations, because, of course, not all complaints will be legitimate, and those complaints can have a very serious effect on innocent individuals, particularly depending on the severity. Just a word to say that employees have a responsibility not to make any false or vexatious allegations, and if those allegations are investigated and the conclusion is that they have been made in such a way, that would generally be dealt with under a disciplinary procedure. So moving on, police action. Now, it's important that the employer considers at an early stage whether the allegations constitute potential criminal activity and whether the police should be informed. Now, sexual harassment is a broad church, and at the severe end, there is a great degree of overlap with criminal offences. We talk about sexual assault, indecent exposure, voyeurism, stalking, and potential some communicative offences, all straddle both sexual harassment and criminal offences. Where we have identified that there could be a referral to the police, it's generally of note to ask the employee, so that's the complainant, whether they actually want to support a referral to the police. The only exception would be if we determine that there is an immediate risk of harm to the complainant or potentially another individual. If a referral is made, it's important to be honest and open with the police regarding our investigation and disciplinary process. And just to state that the ACAS Guide on Disciplinary Grievance outlines that where the matter requires prompt attention, the employer will not need await the outcome of a prosecution before taking fair and reasonable action. You can, of course, appreciate that that a case to a referral to the CPS may take months or even beyond that, and we cannot sit on our hands while that investigation is ongoing. Moving on, mediation can play an important role in resolving workplace conflict, with the Justice Project finding that although it is of use, it tends to actually only have the desired effect when it's voluntary and other options are available to the parties involved. Just to set out that it should never be used as an alternative first step to responding to such allegations. Effectively brushing under the carpet, we'll throw you two in mediation and work it out. That is not generally the intended approach, because a session of mediation will involve often contrition, acknowledgement, acceptance, and possibly even an apology in order to rebuild those relationships. And of course, any form of mandatory mediation or arbitration for harassment should be avoided. We have seen many firms, many businesses in the press suffer reputational damage as a result of their insistence that this be used. IKEA and McDonald's, for two recent examples. In terms of claims, then, and it's interesting because this is fairly misunderstood area of law, in fact, in that whilst employers are usually liable for sexual harassment committed by their employees during the course of employment, there is an exception to this, in that should an employer be able to demonstrate that it took all reasonable steps to prevent harassment, that is a potential defence. As I say, that idea of vicarious liability, the first point, can apply even when the employer does not know that the employee is doing it. And so you can see that is quite a high bar. So the reasonable steps idea is effectively what we've been mentioning in the call so far. It's about ensuring we have a policy, establish reporting lines. There is an awareness within senior management and on what I call the shop floor of the business, because otherwise, and I'll come on to the significance of how this would be dealt with in an employment tribunal in a moment. Just as an aside, employees who resign in response to harassment or potentially an employer's dealing with a harassment complaint may be entitled to bring claims for constructive unfair dismissal subject to eligibility criteria. Employee liability. So again, a fairly misunderstood area of law. Now, just because you are not the employer, it doesn't mean that claims cannot be made against you. Often in cases of this kind, and in fact all discrimination cases subject to limited exceptions, discrimination claims can proceed against a business employer and an individual aggressor of discrimination. And for this reason, you often have claims brought against both entities with a view to recovering sort of maximum compensation and so on. And it's possible because of the Equality Act 2010, which makes employees personally liable for unlawful discrimination committed by them in the course of their employment. It could also be possible for the employee just to lodge a claim against an individual person. It's not actually necessary to sue the employer. And I personally have actually dealt with a case of that kind. And it's certainly difficult for the accused. Any employee, just to finish here, who discriminates or harasses a colleague, again, will not escape the liability because there is a reasonable steps defence. So it does really demonstrate that these changes to the law effectively increase the accountability for employers and employees significantly. So moving on, this is where I really wanted to explain the significance here. Since October 2024, the tribunals have the power to award an uplift of 25% to an employee's discrimination compensation where they find there has been a breach of the duty to take reasonable steps to prevent sexual harassment. And 25% may not sound a great deal, but when we consider that sexual harassment compensation can technically be unlimited, and often awards of this kind are into the several tens of thousands, you start to look at actually that 25% becomes thousands, if not tens of thousands again. And essentially, the development represents a significant change then, as I mentioned a moment ago, in the accountability required from employers for presenting sexual harassment in the workplace. Just to conclude, the European the Equality and Human Rights Commission also have the power to investigate an employer when it suspects they have committed an unlawful act, issue an unlawful act notice where an employer is found to have breached said act, and require it to prepare an action plan setting out how it will remedy any continuing breach and prevent future breaches, entering into a binding agreement with the employer to prevent future unlawful acts, and seek a court injunction to restrain an employer from committing such an unlawful act. And these things are publicised widely and contribute to significant reputational damage. So thank you for listening. That is all from us. We'll now take any questions that you may have.
Thank you so much, Kurt and Anjali. I'm sure everybody will agree that was such a comprehensive presentation, and thank you so much for your time and sharing all your expertise with us as well. One question was, will you be able to share the slides with the viewers? Are you happy to do that?
Yes, of course. I think we said we would liaise with you, Liz, and you can circulate those slides.
On. I'm happy if anybody wants to contact me, if they would like contact details for Kurt and Anjali, then happy to forward on any further questions. Often we end these sessions and then people have questions that they think of later in the day. So if anybody has any questions, please contact me and then I can put you in touch with Kurt and Anjali directly. I think for me, I think my question would be what to do, what to go away, and the first steps. Would it be to put the risk assessment in place? Would that be your advice? Sorry, you're both on mute.
Hi, Dora, I'll take this one.
Okay.
So my advice would be to look at the EHRC 8 steps, because, as I said, that is the starting point really of what you should consider as a business. And as one of those steps includes completing the risk assessment that I spoke about.
Okay.
I think.
Sorry, somebody was also asked whether there are any risk assessment templates that can be found to help with this.
Yeah, so we have a risk assessment template that we would be able to offer to you. So if you would like to have that, then please do get in
That
touch
would be
as well.
amazing. All right,
Yeah.
lovely. Another question. Somebody said, you mentioned that there can be historical claims. How far back can you go?
Yes, thank you. I will take this one. So in terms of historical claims, I'm sure we're aware there's a general time limit for instigating action in the employment tribunal, and that is 3 months less a day from the last action complained of. And it's quite easy to determine limitation periods and so on where it is a singular act. I was dismissed on 1st of March, and therefore your deadline is going to be the 30th of June. The 30th of June. It's different for discrimination claims because essentially, unless it is a standalone act of discrimination, it becomes quite blurred. Often these things will take a form of continuing conduct. So, i.e., if you took any kind of race discrimination claim, you might say, well, I didn't get the job because of my race, and I was subjected to this comment a few days later, and then actually I was put on a performance improvement plan. And so in a sexual harassment context, what the tribunal will do is look at every allegation of sexual harassment and determine whether they form part of a continuing course of events. So I'm sorry, this is a long-winded answer, but what they might say is if the initial allegation of sexual harassment happened, they will look at the employer's conduct in the immediate period thereafter. And if there is an allegation that they have continued to suffer detriment or discrimination because of having raised those complaints, the tribunal could pull the pieces together and still consider that actually they are in time for the purposes of legal action. So technically, you can go back as far as the allegations go back.
Okay. All right. Okay. Right. Well, that concludes the questions. Like I said, if anybody has any after we end today's session, then please let me know. Once again, thank you so much, Kurt and Anjali. It was such a good presentation, and I think we've all learned a lot on what we need to be doing and making sure that we get all our policies and risk assessments in place.
Sorry.
Oh, yeah, go on.
Just a final word from us, if that's okay, please. So, of course, we are, as Anjali mentioned, a full-service law firm. Anjali and I are a specialist employment solicitors, and as such, we can provide any further support that you may need, whether that be the training we referenced for staff and other senior management. Risk assessments, we can assist with preparation of those. I think we had a question about a template in the chat. And ordinarily, we wouldn't recommend issuing a template because they ought to be really bespoke to the risk, and certainly we could help with that. Checklists and guidance notes, we can certainly provide those and assist as necessary. Be it staff surveys and feedback forms for engagement purposes, we can assist with the drafting of a sexual harassment policy, should that be of interest. And ultimately, for all your legal needs, we can produce a free legal health check. So if you want some assistance or would like to discuss any of those at all, feel free to get back in touch and we'll happily have a chat.
Okay. All right. Thank you very much. Thank you, everybody, for attending. Hope the rest of your day goes well. All right. Thanks. Bye-bye.
Thank you.
Thanks all. Bye.
Bye-bye.